Welcome. Congratulations. You made it to our 1, 2, 3 easy video for protecting your family, wealth, estate, business, retirement, and children. Yes, even if you have lawsuits or judgment risks. This is a very short introductory video, so wait to the end for more detailed information. I'm Richard Rydstrom, a California lawyer with over 33 years experience. I'm rated 10 out of 10, superb. Sit back and relax. Let me try to fashion a clear, confident path for you to get protected and make it as easy as 1, 2, 3. Let me give you an overview of almost all of the choices in protection planning, whether you're high-end net worth, cash rich, or not rich at all, and just need family protections to avoid probate and its delays and expenses. Before you can decide if a living trust and its related documents are appropriate, I think someone should at least show you all the choices usually available. Here is the big list made very short. 1. The Revocable Living Trust. The public knows this device as a living trust. The living trust is most often used to avoid probate, its costs and delays. It is generally a tax-neutral device. However, you may use this trust to invoke maximum estate tax exclusions, as wills can, but the living trust will avoid probate, unlike the will. The trust and its related documents enunciate your instructions and intent as to you and your family members, and your assets, during your lifetime, during incapacity, and in the event of death, and avoid probate at the same time. That's why it's the most sought-after device for the rich or informed. You don't have to be rich to have a living trust, and most persons should consider a living trust. Contrary to myth, generally it is not intended as an asset protection safeguard, at least during life, while it is revocable. For asset protections, you should watch our advanced videos and see item 3 below. A pour-over will is a catch-all for property left out of the living trust for any reason, if not otherwise designated, like with a pension, life insurance or retirement pod, or other trust like a life insurance or children's trust. 2. Related powers and nomination documents. You should also predefine healthcare, incapacity, end of life, relief from pain, agent decisions and designations in health and asset directives. You should also name the conservators over the person and estate, usually your spouse. Additionally, you should define the attorney-in-fact agent for asset management decisions. These documents are used in most living trusts as well as along with other devices. 3. In larger estates, it is often advisable to put certain assets in various other devices, for example, LLCs, children's trusts, life insurance trusts, C or S corporations, private retirement trusts, IDITs, for asset and risk protections, as well as for tax reduction reasons. Interests assigned into certain other devices may be assigned to the living trust. In California, to protect cash and retirement property, we have one of the most powerful devices known as the statutory-styled private retirement trust. It's not just a pension device holding trust. Even if you are rich, and will use advanced devices, you should also use the living trust under item 1 and related documents under item 2. Well, I think we did it. Congratulations for watching this intro video. Now you have to make an important decision. What is the next video you need to watch? Video 1 for living trusts, or video 3 for advanced clients? If you have a business, you should watch video 2. Or, you can decide to book a call with WealthAttorney, and for a limited time directly, with California attorney, Rich Rydstrom. See the link in the video description or call 877-WIN-4-U. Thanks again, Rich Rydstrom, California attorney, WealthAttorney. Legal notice. IRS Circular 230 Disclosure Notice. To ensure compliance with IRS requirements, we inform you that any U.S. federal tax advice contained in this communication is not intended or written to be used, and cannot be used by any taxpayer, for the purposes of I. Avoiding penalties under the Internal Revenue Code, or E. Promoting, marketing or recommending to another party any transaction or matter addressed herein. Any legal advice expressed in this message is being delivered to you solely for your use in connection with the matters addressed herein and may not be relied upon by any other person or entity or used for any other purpose without our prior written consent. This information is for general non-exhaustive educational purposes only. May be deemed an advertisement by State Bar. All rights reserved in trademark and copyright. Copyright 2022 Rich Rydstrom by Rich Rydstrom, Esq. The California Attorney. 877 WIN 4U, info@wealth.attorney.